welcome everybody. We have an exciting webinar. This is a bi-weekly webinar that I host with Jim. We love adding value to the agents. For people that don't know, my name is Ryan Poole. I'm an agent as well. Been doing this over 20 years. I'm also the founder of RealTrade. Actually, we launched this about 2.5 years ago now, and we have thousands of users,
How many
thousands of
users
buyers
do you
and
have,
sellers.
Brian?
What's that?
How many users do you have? What are you up to?
We have over 2,300 agents now, Jim, register on the platform, thousands of buyers and sellers, and we have some great service providers like yourself. So, the big differentiator on RealTrade, I tell agents, it's free to join. Best thing is you can get free leads off your listing. So imagine that. So Jim likes to say we're the home of the double dip, but we love hosting this bi-weekly webinar, adding value to you agents. And this is an exciting topic here, is personal property. I've actually had deals almost blow up over this exact issue. And it's pretty amazing to actually have a real estate attorney that has a lot of experience in this particular part of a real estate transaction with personal property. So go ahead, Jim. Next to you, he's my co-host, amazing entrepreneur, not only real estate attorney, the core founder of New Path Title, amazing closing software, Title Leap, and has his own law practice, James Brown Law. So go ahead, Jim, take us away.
Thanks, Ryan. So the goal of today is we're going to talk about the effect of, and I call it, you don't want to be that guy. You don't want to be that agent. You don't want to be the agent that's throwing information into the deal that may or may not be accurate. So the goal of today's session is to talk about how to accurately discuss mixed property transactions. And what do I mean by mixed property? I mean real property being sold with personal property. Our goal in this podcast is to bring you stuff you won't hear anyplace else. There are no dumb questions. I want to keep this to 30 or 45 minutes. You can turn on your camera if you can, that way I can see your reaction. It helps me gauge what we're going to do or if people are responding and understanding. There'll be question and answer at the end, and Ryan will go over some more time-saving tools you guys can use to make some money. And I would love you to text me future topics you want to talk about, or put them in the chat. And any questions you have, put them in the chat. We have a small group today. It's summer, or it's approaching. It's approaching summer.
It feels like summer. It feels like summer.
So we're going to do two topics today. We're going to do one real quick, abatement, little known IRS trick, and then we're going to go into mixed property sales and how to properly discuss personal property and the mix of personal property and real property selling at the same time. All right, having said all that,
I want to add too, if you have any questions, we want to keep this like a conversation. Go ahead, you can raise your hand, ask them in the chat. We got an attorney here, so we can get all our questions answered here on this particular topic. So go ahead, Jim. Feel free, you can share your screen. There we go.
All right, first thing we're going to talk about today is abatement. The IRS has a gift waiting for your clients with lingering tax penalties. I just learned about this myself. I cannot tell you, I cannot stress enough how much this opened my eyes and blew my mind. If your client's credit is continually being damaged by IRS fines, and the fines are from late filing, paying late, paying the wrong amount, or some third-party failure, your client may qualify for what's called first-time abatement. If your client and they qualify for first-time abatement, and you guys don't have to memorize this stuff, obviously. There's an outline that's available under Realtor resources on our website. If your client has a history of good tax compliance, generally that means no penalties on the same filing issue for 3 years prior, never applied for an abatement prior, and the penalty is not a result of electronic federal tax payment failures. There are a few more technical criteria, but they may qualify for an IRS first-time abatement. IRS first-time abatement website has all the forms and instructions. It's not too hard to understand, and it gives you some examples of who qualifies and how. It's relatively short. I'm going to tell you guys, I've never seen anything that the IRS offered that was so beneficial and so easy to use. Abatements can be requested over the phone, and in some situations actually granted tax relief in the phone call. Mind officially blown. When was the first time, when did you ever contact the IRS directly? And as a title agent, we contact the IRS a lot and get relief in a phone call. Or you can send in a form requesting the abatement. I give you the form, there's a link to it here. A third party can make the request for a taxpayer with the power of attorney. You can get a power of attorney form. I gave you the link here. So that means bookkeepers, accountants, CPAs, anybody can request on their behalf. If you have an office manager that's pretty savvy, they can request on your client's behalf. But I don't recommend that agents do this for their clients. So I'm going to give you a personal story. We had a client who missed a FERP filing deadline. So FERP, everybody knows what that is, Foreign Investment and Real Property Tax Act. That's where the title agent takes some money and they put it in escrow and they send it to the IRS after the sale. So they missed the FERP filing deadline. The penalties were huge. They spent 2.5 years and thousands of dollars on CPAs and accountants. The fines were growing daily and almost up to $20,000 on a $10,000 penalty. The IRS was continually sending notices to the taxpayer. The file was in review and needed another 60 days to give an opinion. How familiar does this sound, you guys? If you know anybody that's ever dealt with the IRS, they are the most inefficient animal on the planet. I hope there are no IRS reviewers on this. This went on for over a year. Then the other day, I just happened to be having lunch with a really, really knowledgeable CPA. And he says to me, and I apologize for being late. I showed up for the lunch and I apologize for being late. I said I was dealing with an IRS agent. I didn't know he was a CPA. And he said, oh, what was the issue? And I said, oh, we haven't. I gave him the fact pattern. And he said, have you ever tried to file for a first-time abatement? And I said, no. And he said, is your client's tax record squeaky clean? And I said, I think so. So right after lunch, I filed the abatement. And I did it myself, right? And they had hired CPAs and they had hired third-party bookkeeper types to do this stuff, accountants, with no success in 2.5 years. So I filed the abatement myself, and I know nothing about filing with the IRS. And by 8 o'clock the next morning, I got 100% relief.
Jeez.
In 40 years of dealing with the IRS, I never saw anything like this. Full pause, full stop. If you guys know anybody who owes penalty money to the IRS, tell them about this tool. I mean, if I was an agent, I would even send an email blast to all my clients in my database saying, hey, if any of you guys know, if any of you clients, if any of you buyers or sellers, anybody you've worked with over the past million years have reoccurring fees with the IRS, there's a tool you can use. Ask your CPA or your bookkeeper or your tax preparer if this is appropriate for you. And now you become the agent that's an authority on a topic and you're in front of your clients another time. I'm always going to give you tidbits. Like last week, we talked about the beneficial interest filing. So all your clients that have entities that are buying properties, the BOI reporting is a good tool to get in front of your clients. This is a good tool to get in front of your clients with. It's all about repetition and establishing you as the expert. What you don't want to do is go too far. So I try to give you guys enough to break the ice on the topic, but what you don't want to do is go down the rabbit hole of explaining this stuff. Anybody have any questions?
No, that's awesome, Jim. You just look at like a knowledgeable agent, right? And if you can save your clients money, I mean, they're always going to remember you. You know, people that have saved me money or made money for me I always remember them for sure.
Yeah, and you become that go-to knowledge source, and then when they need a real estate agent, you're the go-to knowledge source. So here is the main topic today: personal property contracts and Florida real estate sales, the DOR, IRS, and general risk misconception on the impact of property taxes. I'm going to retitle today's discussion as "Don't be that agent." Don't be that agent who suggests something and they don't really understand the full breadth of what they're suggesting. I did a transaction not too long ago for an agent, downtown West Palm Beach, tons and tons and tons of sales, long history in the business, and they were trying to explain to me the effect of personal property in a real property sale, driving down the price and saving on taxes. They had done, this person had done hundreds and hundreds of transactions. I was amazed when they displayed to me their lack of knowledge of the issue. So if they're out there advising their clients and they're giving them this information, what is that? That's an open door for liability for the agent. So the hard part for me to do these things is to break down the information for what you guys actually need to be the knowledgeable agent and come across as sophisticated and educate your clients. But we don't want to go too far down the rabbit hole that you're actually giving them legal advice. So I'm going to give you guys general advice on how to handle the topic. and then you leave it up to your client to talk to their tax preparer or their CPA. Almost every agent has or will experience this. You have what looks like a straightforward deal lined up. You are either near signing or just have a signed contract, and all you need is a closing. And then the buyer says, I don't want to be taxed on the full purchase price. Let's put a value on the personal property and reduce the value of the home to save on property taxes. If you haven't seen it, you're gonna see it. And the worst part is if the buyer's agent suggests, let's make a personal property contract to drive down the home value for taxes. Don't do it.
Don't do it.
If you're gonna do it, just the first thing you want to say is talk to your CPA, but don't do it. And there's a whole host of reasons why that we're going to go over in a minute. Here we outline the high points of just some of the issues, so you know how to respond to your buyers and sellers, and any one of these issues can be explained much further, and this is not a simple topic. And I caution you guys, almost none of this applies to commercial transactions. It's a whole nother animal. Right now, we're talking about higher level real property transactions for non-commercial properties. And when you talk about commercial, there's a whole lot of other factors to play in. I call the sale of personal property at the same time I call the sale of real and personal property at the same time mixed property sales. Real property is sticks and bricks and dirt and the home that the lot sits on, and the lot that the home sits on. That's a real property sale. If it's attached to the ground, or it was built with block, or it was built with wood, that's the real property. The personal property or the non-real property is everything else that's not real property. Sofas, art, silverware, pool tables, everything else. Generally, everything that's not nailed down or screwed to the structure is going to be personal property. There's another whole group of property called chattel, but we won't go into that today. It's not important for this discussion. Line 15 of the contract has a list of let's see, can I pull this over here? Can you see the contract, Ryan?
Yes, I can. Yep.
Line 15 of the contract has the personal property, non-real property that most of the time changes hands with the purchase and sale. And so you can get an idea of what the personal property is here. And then always, if you have personal property that's excluded from the sale, you can list it here. But you're going to have additional personal property sometimes, and this isn't really the topic today, but you want to make a detailed addendum because you don't want to have a situation come up at closing where I've seen jilted sellers or buyers upset about a piece of silverware or an old plate. Personal property transfers under a bill of sale. Real property transfers under a deed. You'll see sometimes people put personal property on a deed when it's not appropriate, like a trailer VIN number on a trailer for a trailer home, or a parking space or something like that. That's not technically real property, but real property is the sticks and bricks and the dirt and the lot. As a general reminder, if you're going to list personal property, do it with a high degree of specificity, even if it does not have much value. Again, I've seen people argue over $100, less than $100 worth of silverware or a plate. And I've had buyers and sellers on the phone with me, and they say, it's just the principle. What's a principle, right? The principle is how you make a small fortune. You start with a large fortune and you try to prove a principle. That's how you make a small fortune, proving principles.
I mean, I've had deals almost blow up too, where they bought it fully furnished, right? And the seller, or the day before, the final walkthrough, they took out all the utensils, all the silverware, all the pots and pans, and the buyers were under the impression that, hey, that was included when we said it was fully furnished. Guess who ended up buying new pots and pans and glasses and silverware?
And we can go down that whole rabbit hole of personal property stories, because I've got a million of them. And the reality is they're easy to prove what was in the property, even if the agents didn't do a great job. You go back and look at the pictures from the listing,
Yeah.
and now you've got a whole bunch of evidence as to what was in the property. From a title agent's perspective, the real property sales are usually handled one of two ways. Either it's a contract that calls out the personal property with the real property values. Tajay, and I were talking about this yesterday. So you have a contract, and the title agent reports and pays doc stamps on the real property value only. For example, the sale is 1.5 million and the paragraph 20 or an addendum says that the real property is 1 million and the personal property is 500K. Everybody clear on that? So
Yes.
typically the title agent tells the Department of Revenue, or the clerk who tells the revenue clerk, the recording clerk who reports to the revenue clerk, the real property sale value. It's in a DR 219. That's not important, but we can put whatever value we want in there. Tajay, if I say something that's not right from a production standpoint, don't hesitate to chime in. And whatever value we put on the DR 219 is going to be the value that gets recorded for the purchase of documentary stamp taxes. The contract, and then the other way they can do this is the contract only calls out a real property sale, and the personal property sale happens between the parties, separate apart from the title agent. Number two can be tricky. What if one sale does not happen and the second sale must be contingent? On the first. So you have situations where one sale doesn't happen and then they're trying to force the sale of the other property. Not impossible to do, to make transactions dependent on the other transaction, but agents sometimes aren't sophisticated enough to know how to do this. And then you have a situation where people are trying to argue over what they're obligated to. And I've seen that a few times over the years. Generally, if there is a lender, the second way doesn't work because the lender doesn't want to see transactions that aren't recorded on the settlement statement. So we have to sign a document at every closing that says all the transactions that the title agent is aware of exist on the settlement statement. So if you have side transactions, then the title agent either has to make a false statement or not have knowledge about it. So there's two ways that they can occur. Either the value is on the contract, and then there's a statement that they're going to write down the value of the real property, or it happens in a separate transaction if there's no loan. Does anybody have any questions on that?
It's good.
What realtors and rules govern mixed sales, AKA if the real property sale value is low, who is going to have an issue, who is going to send a notice of violation, and who is going to send a fine? Who are you going to hear from? Documentary stamp taxes and the Department of Revenue. That's the biggie. The Department of Revenue hates missing out on doc stamps. The fines are heavy, and the statute, Florida 201.2, does not say who's ultimately liable, buyers or sellers. So now you've done this transaction to appease your buyer, and now you're a seller, and now you're getting notice a long time after the transaction that the Department of Revenue has heartburn. And the tax collector, the property appraiser sends out notices to everybody if they see a value in the community that was artificially low or appears to be suppressed, and they want to know about why did the property, they contact the title agent, they contact the buyers, they contact the sellers, and they have you sign written statements as to why stuff was low. Or they ask you questions about the condition of the property. We'll get more into that in a minute. But the reality is there's a whole lot of triggers, and it didn't used to be the situation where the departments were talking to one another. But I was talking to an attorney yesterday, and now the Department of Revenue, who collects doc stamps, and the recording clerk, they're all communicating. And with software, we can all see how that would be easy to do.
They
If
want
you
their pound of flesh. They want their money.
property taxes, the property tax appraiser and the tax collector, same result, different governmental authority. So if you're suppressing taxes, who's missing out on revenue? The tax collector is missing out on revenue. They're not happy. Here's the biggie that everybody forgets: the IRS and and federal income taxes. So imagine the feds coming after your seller for a deal that everyone thought helped the buyer on property taxes. And now the federal government's calling your seller. And you were that agent who suggested we do a real property, personal property mixed sale to suppress pricing. You don't want to be in that situation. The sale price is artificially low. The IRS could claim the seller owes more in income taxes. Here's the one that everybody forgets if it's not personal property, if it's not a personal residence: intangible taxes in the Department of Revenue. As you increase as you decrease the real property value and you increase the personal property value, and it's a rental or a productive property, now you have an intangible tax burden. Whose burden is that? The seller's. Whoever's in title on the first of the year when the property is sold. So if it sells in July and your seller's in title on January 1st, the seller's responsible for the intangible taxes. In all my years of doing this, I've never heard an agent volunteer this information that they were aware. I can't imagine that buyers and sellers are being educated on this issue. And if intangible taxes aren't paid and the Department of Revenue catches up, they're coming after the seller. Period. End of story.
Yep. I guess too, I want to mention too, maybe we'll get into it, Jim, but like I've had, for instance, I've had sellers that have offered where they own the property with an entity offering to the buyer, hey, you can just, take over this entity, that owns the property, and then it won't be a recorded sale. You won't pay higher property tax and you'll save a bunch of money. And then the seller's going, well, now my property is going to be worth more because their net operating income's higher. I guess we can maybe touch on that a little bit.
No, that's a great topic. So it's not exactly what we're talking about today, but we're talking about ways to suppress property tax values.
Yeah.
And there is a problem with doing those transactions that way. And what Ryan's describing is Jim owns Jim Property Holdings LLC. And Ryan wants the property that's the only asset of Jim Property Holdings LLC. So instead of Ryan buying the property, Ryan's going to buy the shares of stock in Jim Holdings. And so now Ryan owns Jim Holdings and he gets the property by virtue of the fact that the holding company owns the asset. And so to the Department of Revenue, there's this thing that they created under Florida Statute 201.2 called the Notice of Change of Ownership Control of Non-Homestead Property, where the sale of stock from Jim to Ryan triggers a documentary stamp tax. And the documentary stamp tax payment will then trigger the tax collector to know that there was a change of ownership, and then they'll go out and get their property tax. So the state, to make it really simple, the state says if you're going to transfer the shares of stock of the company instead of the property, that's actually a documentary stamp taxable event. When you file this form and you tell the Department of Revenue that there was a change of the shareholders, that's going to trigger the tax collector to come after you for taxes. We have this exact case going on in my office right now. I don't know any way around it, and I'm dealing with an attorney who insists there is a way around it. And when I ask her for evidence or some type of supporting law, I don't get anything. So I'm going to tell you right now that's good law, and I can't find any way around it that I'm aware of. So here's the big question that everybody asks me, or they don't even ask me this. Here's the issue that real estate agents tell me they know the answer to by virtue of the way they're explaining it to me. They think they know the answer, and unfortunately, the vast majority of times they're wrong. Does the sale price determine the future taxable value? I cannot tell you how many agents have told me emphatically that that's how taxes are calculated. There is no easy answer, but the easy answer is no, they don't. It's the sale price does not determine the taxable value. The hard answer is why and how taxes are calculated, and I could write a book on this, just this topic alone. The best answer to tell your buyer and seller is, and I gave you a little sound bite here that you guys are more than welcome to use, and it simply says, your sale will only be one comp in the pool of comps the property appraiser uses when calculating your future taxable value. They use what's called a mass appraisal system. It's run by a computer, not a person. And there are plenty of properties being taxed at values in excess of the sale price. Fort Myers has lots of appeals pending for tax values far in excess of the last sale price. So the easy answer is that, and that's what you tell your client. If you're going to be one of the agents who tells their client that the sale price will crank it down to control your taxes, that's just not accurate. Our resident expert on tax appeals is Adam Rosenfield. I gave you his information below, and he said that the mass appraisal software bases its valuation on three primary factors: location, condition, and square footage. And there are a couple of other minor factors, but these are the factors that it looks at. So it's just a piece of software, and then if you don't like the value that's been assigned, you have a little window of time, you can file an appeal. He does not charge for his appeals. He does appeals for properties over $1 million. Typically in sales under $1 million, people aren't trying to suppress values, but we do see them once in a while. All this is a big buildup to the part we've been waiting to talk about. What's the best advice a real estate agent can give their buyer and their seller on these issues? Here's the part where everybody should tune in. Grizel, you got here at exactly the right time. Your timing was impeccable. If your buyer or your seller says, we want to do a mixed sale, or if your agent on the other side says, we want to do a mixed sale, here's what you say. Please consult your CPA. Grizel, I'm going to back up for a minute just because we have a small group. I'm going to send you the outline, but take a look at this one paragraph. This is what you want to tell people if they say we want to do a mixed sale, real property and personal property, in an attempt to drive down the value for taxation. So the first thing you want to say is you got to consult a CPA. If you don't have one, I can refer one to you. I gave you a list below of little CPAs that we've used that I really, really like, that are easy to work with. Here's the biggie. So if the agent suggests that you want the CPA to tell the buyer or the seller it should be done or it shouldn't be done. And then here's the biggie. Be prepared to get appraisals. Ryan, how many deals have you seen where agents told you they ever got appraisals in their mixed sale contracts?
Never.
And then as I was doing the research on this, it's the only good advice. And what you have to do is you not only have to you got to get 2 appraisals. You got to get an appraisal of the real property, and you got to get an appraisal of the personal property, the non-real property. And then everything has to jive. So in our example, if you have that $1.5 million sale and you have an appraisal for the personal property of 200 grand and an appraisal of the real property at $1.2 million, because it's a $1.5 million neighborhood all day and night, and the property's in good condition, and the appraisal is conservative, and it comes in at $1.2 million or $3 million or whatever the number happens to be. If you don't get to your $1.5 million sum, you're going to have a problem. And typically the transactions I see that are problematic, that I've never seen appraisals on, are the personal property side. Nobody gets an appraisal on either side, but when they start talking about the nature of the stuff in the personal property column, it never adds up to the number that they want it to add up to. And I've seen agents go to bat with their clients saying, this is absolutely the way we got to do this. And here's how they're so emphatic in their explanations. And that's where the danger lies, right? I hope this goes without saying the 2 values have to add up to the total sale price. So here's some parting thoughts. Always check how long the seller owned the property. If the seller owned the property a long time, the taxable value has been capped for a long time, and the buyer's increase in taxable value is going to potentially be large. So that's just something you do whenever you're dealing with transactions and you get into it. It looks like people are signing up. I don't know how early in the deal, Ryan, you start looking at how long the sellers own the property. But if you're on the buy side, you may or may not bring it up, but you want to know in the back of your head what can happen. We all know that there's
Especially, the property's been, I deal with investors too that have investment properties or buying from fellow investors. But if it's a traditional residential sale and if the property's homesteaded, you definitely want to point, and you're representing the buyer, point that out to the buyer. Hey, this property's been homesteaded. They bought it in, 2000. They've owned it for 20 plus years. Your taxes are going to go up from this number that we see on the MLS that, all the agents are looking at. The buyers are looking at the same listing info on the other portals like Zillow. Oh, wow, the taxes are only $1,500 on this property. Well, that's going to change. So,
and lenders are waking up to this. Lenders are starting to ask, what's the new tax going to be? And there's provisions in the contract for new construction, and it's trying to set expectations properly. We'll go over that in another podcast. But for the purpose of this discussion, even if the property is not homesteaded, and we're seeing people selling properties they've owned for a long time, so even if the property is not homesteaded, it's still capped. It's not capped as hard as homestead property, but if they've been renting it since 2000 and they want to cash in on this increase in values, now they're going to sell the property. The buyer, who's maybe not as sophisticated as they could be, thinks they're going to have this super cheap tax. It's just not going to happen that way. And sometimes the lenders set false expectations, unrealistic expectations in the buyers, because they're doing this forecast based on suppressed tax
Let me
value.
let me ask you on the property appraiser's point, because you did cover it earlier, Jim. They're taking everything as a whole. They're not just going off the sales price, right? So when they're adjusting that value every year, let's say they own it for 20 years and it's not homesteaded, right? I mean, they're dictating their value more or less on the current sales, and it can go up or it can go down. But you are saying they do favor that property if it's been owned a long time and aren't maybe adjusting it as high as they would say one that sold 5 years ago, or how does
Well,
that
I
work?
can't tell you exactly how the algorithm works, but I can tell you for sure that properties that have been owned for many years by the seller, now they're out back in the market, they find a buyer, they make a sale happen. I've seen the values ratchet up dramatically. I don't know that they're trying to overcorrect, but then again, I don't control the algorithm, but I would hope they're not trying to overcorrect. I hope they're
What was Ryan's question? I'm sorry.
No, I mean, I was just saying if the property's not homesteaded, right? And like Jim is pointing out, and the property been owned for 20 years, Jim's pointing out the fact that the current appraised value might not be in line with the other ones maybe in the neighborhood. And it will go up considerably after the sale. But I do want to point out that
Right.
the property appraiser doesn't go on the sales price, and all of a sudden that's the appraised value, right? Of the taxable value. They're taking as a whole the whole area of the recent sales and the whole area. And that's what I point out. I do point that out to my clients because a lot of them go crazy, like, oh, it's going to go way up the sales price. I'm like, listen, it's not going to be necessarily exactly the sales price. It's going to
right.
be the rest.
Right.
I say,
No, that's
especially with condos too, because I'm like with condos, I'm like, you can't just have one sale and all of a sudden jack up everybody's taxes in that whole building, right? Because there might have been something with that sale, right? That's a little bit different. It's fully updated and yours isn't. And anyway, there's a lot of
Well,
different.
you bring up a really important point, Ryan, and that's one thing I saw. I saw in a transaction, there was somebody that had a big condo on that little stretch of highway below the Rotary at the end of Southern.
Yeah.
So there was a condo, somebody owned the condo in there and they wanted to buy the adjacent condo. And so they were buying over market because they wanted to connect the two condos. So their purchase was dramatically over market because it was just strategically located and the seller knew they could lever the buyer into a higher price. But when the tax bill came out, the tax bill was dramatically lower than the sale price because it
Yeah,
was based on the comps.
exactly.
If they had based it on the sale price, the buyer was concerned they were going to get clobbered in property taxes. But when the bill came out, it was dramatically lower than the sale price and everybody was happy. So they had $1 million unit upstairs and $1 million unit downstairs. And I think the downstairs unit, they paid, it was, grossly disproportionate, 1.5 million or whatever. And they made
So
a
hopefully they homesteaded the more expensive one right at that point and locked in the appraised value, right? Because that's obviously with homesteading the big value add, right? You lock in.
That's an interesting question. I have to unpack that one a little bit. So they had existing property and they added property to it. What happens to the homestead valuation? Is it ratcheted up for the value? Yeah, I'd have to think about that one a little. And there's some restrictions on homestead that people aren't aware of. So there's urban property and there's rural property and there's size limitations in homestead. That's a whole nother podcast. But the point of this podcast is always check how long the seller owned the property. In 20 years of private practice, I've taken thousands of agents. Oh, I've taken thousands of agents' calls, and only a handful of times heard an agent say, "I'm going to tell my client to talk to their CPA and get real property and non-real property appraisals." Yeah. Again, 20 years of doing this, hundreds or thousands of phone calls. That's the go-to. Your client starts having this conversation, that's the go-to.
Yeah.
Many, many times agents I've taken calls from and we've closed in the title side of the business, and the agents were the sole source of information and valuation for the buyers and sellers. Again, I had a conversation with an agent where the agent was going to the wall with me about how this is legit and they could put this big pumped up value on the personal property and it was going to drive down the real property value and we're only going to file the documentary stamp taxes on the driven down value. And that agent, I hope nothing happened. I haven't heard from them in a while, but I hope nothing happened to them as a result. Advising buyers and sellers on tax issues is a dangerous place to be for an agent. And I've seen agents sued for by buyers and sellers on this issue when the Fed, DOR, or tax collector comes knocking. Having said all that, there are absolutely bona fide mixed sale deals. We did a furnished home a while ago. They had appraisals. There was a CPA that advised them on it. The CPA was very involved in the transaction, and those guys, those agents are sleeping tight. My advice is don't be that agent. Don't throw out the mixed contract option as a way to lower taxes. And if your agent, if the other agent does throw that out, the big takeaway for you guys is here's a little sound bite that you guys can use to manage the issues with your client. Your sale will only be one comp in the pool of comps the property appraiser uses when calculating future tax values. That's
Yeah.
the sound bite right
I mean,
there.
that's gold right there. You know what I mean? That really is, you know, because especially if you're a buyer's agent and they're going to be so worried that, oh, we're going to pay such higher taxes. And like, listen, every year it's going to be adjusted and it can go up and it can go down. I've seen
Yeah.
it go down. Like, if you've been in this industry long enough, you've seen the taxes go down, you know, so
There's a
things can,
whole
yeah.
visual graphic I can show you guys for how taxes go down and how they do a recapture. It's so complicated, and it's actually pretty interesting. But if you guys do
But
have tax,
what is amazing, yeah, I want to say this. What is amazing for your clients, you're going to tell them like how important homesteading is if it does go down, you've now locked in that price of that down. You know what I'm saying, Jim? Like
yeah,
it's incredible. Like, so now you've locked in that price when it went down. Now it can only go up 3% a year. You know, your appraised taxable value can only go up 3% a year. And if it goes down again the next year, guess what? It goes back down and then can only go up 3%. So there's a lot of value on the homesteading. Can't say
do
enough
you
about
know
that.
how many dollars the state collects unnecessarily because sellers don't know how to the dollar value in 1 year the state collects in property taxes that are collected where sellers didn't properly take advantage of homestead and the transfer, the portability of homestead, hang on to your hat, $1 billion.
I mean, that's just incredible. So why
Five
don't you just
billion dollars in property tax
And listen,
collected.
I let all my clients know about portability because it is massive value as an agent. If you let them know, you're like, what? You're just saving me thousands of dollars. Why don't you give just a quick 30,000 foot version of portability, Jim, just so everybody, you know, has it in their quiver, you know?
So portability is the concept that you were in a piece of property. Let's say you bought it 100,000, the value went to 500,000, you owned it for a few years, and now you want to sell it. And during that period of time, the value of the property from the taxable value of the property went to 150 grand. So now you have a $500,000 property with $150,000 tax burden. You can take that benefit, you can take that cap
350,000.
and transfer it to your new property. So the first $500,000 in value on your new property, you're only going to be paying tax on 150 grand.
Love it.
So if you're downsizing or you're same sizing, your tax burden on your new property when your buyers are freaking out, oh, I can't afford this property, it's too much money. You know, freaking out is dramatic. But if they have questions, the sophisticated agent says, no, let's go to the tax portability calculator on the Palm Beach County Property Appraiser's website. And I think many counties have them now. And calculate what the portability is, and you can show your client in a graphic format how that works. So Federico has a question. How long is portability good? It sticks for if you leave your homestead and you go to another piece of property, you have to go to another property and file homestead within 2 years, I think it is, but I can get you an exact answer on that. But there is a time period. So the best answer is you don't have to go right into a new property. And there is a time period where you can get the benefit of portability, even if you're not going into a new property, but there is a time cap on it. It's either 1, 2, or 3 years. I want to say it's 2 years, but I'll get you the exact answer. And we can do a whole portability segment.
Well,
There's
we did it actually a good homestead webinar. It's been, what, it was about a year ago. We could maybe revisit that one, Jim.
sure, there's all kinds of
Portability
things.
and the homesteading. It's as an agent, if you're sharing this information with your clients, you look like a hero. I mean, it was amazing. I had a client that got the portability on a new condo she hid. She actually downsized. She's like, Ryan, like, wow, my taxes went down so much. I'm so thankful for the portability and you giving me this information. I had no idea.
There's
You know?
even portability apportionment. So if you're having clients that are divorcing,
Yeah.
a husband and wife, and they're divorcing, and there's a real value in they've lived in a property for a long time. It's a frequent scenario when they've amassed a large homestead portability. It's treated just like a marital asset. So the wife is not going to a house, and the husband is going to another house, and the husband gets the portability. It's a marital asset that can be assigned by the divorce attorney.
Well, I
Here,
mean, yeah, no,
I
it's,
wanted
it's
to
the
add,
gift that keeps on giving. Go ahead.
something really quickly. The first piece is as far as the homestead property and taxes go, Jim and I have also seen, I saw what a buddy of mine called. He was collecting homestead protections on a property in which it wasn't his homestead property. And after 5 or 6 years, the county came back to him and fined him for all the homestead benefits he received over the last 5 or 6 years. But that's also a huge piece of people to think like, oh, I'm gonna have a homestead property in Florida, but I'm really gonna live in New York all the time. Or I'm gonna rent out that property. And he did that because the properties in Miami-Dade and the property taxes are extremely high. So he's collecting homestead on the property while living in Palm Beach for years while renting it out.
you guys, Tajay just dropped gold in agents' laps, right? You can only have one homestead in Florida. Even if you're separated and you're married, you can only have one homestead for the spousal couple. Um, you can't have homestead in other states because many states have homestead type protections and also have a Florida homestead. You've got one primary, what they call situs. Don't give your clients advice that they can have. They're leaving their Miami property, which is what Tajay is describing. They moved to West Palm and they remain taking their homestead in Miami. And I think, Taj, wasn't it a boyfriend girlfriend situation and the girlfriend was taking homestead up
I think
here?
his wife, yeah, I think that maybe him and his wife aren't legally married or something, where his wife was collecting homestead on their property up here.
That's what it was. They were
Yeah.
married and they bought the property in West Palm in her name and they left the property in Miami in his name. And they had different last names and he was collecting homestead, but they were legally married and she was collecting homestead in West Palm and he was collecting homestead in Miami and the penalties were $30,000 very quickly. I think it was 30 grand,
Yeah, it was a lot of money.
34,000 really quickly.
And then the other piece I wanted to add about the reassessment of taxes, what we've seen a lot of here in the title company is when the new tax bill comes out, sellers, based on the contract, have the right, buyers, sorry, based on the contract, have the right to go back to sellers and ask for a reparation of taxes. Because now
Yep.
it's easy that a tax bill can get reassessed 4 times, 5 times the previous year's amount.
What's the section in the contract that's prorations?
Yes, it's like the end part of prorations.
Is that in the special, is that in the standards or is that
I'm gonna tell you right now.
title examination? This is in all contracts. Sometimes the title agent writes something up that, here it is right here,
It's
proration,
on, yeah, it starts in 490.
section 490.
Line 490. There you go.
Line 490, the following reoccurring items will be made current if applicable. And what they talk about is after the tax bill comes out, you use a guesstimate to generate your settlement statement on the year the property closes. But when the tax bill comes out, if the taxes are dramatically higher, the taxes are dramatically lower, either the buyer or the seller can look to each other to recover. Sometimes they sign a document at closing, which eliminates this, and sometimes they don't. It just depends on who your title agent is. But in all contracts, there's the ability to go back and collect tax offsets from your buyer or seller, depending on whether taxes go up or down. Taxes do occasionally go down, but we don't see it often. If you
Yeah, we're just seeing this a lot more because taxes are getting reassessed at a way higher rate. people that had properties for a long time and convincing them to sell, etc. But there's that ramification as far as that tax preparation goes.
And then who's the first person they call? They call the realtor. Every single time they call the agent, you know, what? My tax bill has gone through the roof. And then they go call the title agent after that. We always point them back at the contract. We can do the math. We can help them through the issue, but typically it's justified. Have we ever seen one, Taj, that was not justified where somebody was overreaching or doing something? I can't remember in 20 years.
I mean, sometimes the amounts are very minimal, but it's still owed to the person. There's been people that are coming back for $300-400 and like, causing a ruckus over it.
Yeah, so sometimes we see people that miscalculate it, but typically it's justified. And so you just have to, buyers and sellers have to learn that it's part of, or agents have to learn it's part of the contract. And then when the conversation comes up, sometimes you got to look at the settlement, say the closing documents to make sure it wasn't done away with, and then it's justified. In other words, if the contract says there can be offsets, but the buyer and the seller sign something at closing that says this is a final settlement of the tax values, the contract says yes, the closing documents say no, and so the buyer or the seller has no claim against the other party. There's two great sources that I can give you guys. Adam Rosenfeld, can't say enough about this guy. He does a beautiful job in tax appeals. So if you have properties over $1 million, you have clients with properties over $1 million, and they want to appeal their taxes, he does this for a minimal charge, and then he gets a fee when he's successful in the end. If he takes the case, he's going to be successful. That's been my experience with him. He's really, really bright guy. He's a young guy. He's got a ton of energy and he knows the topic inside and out. When you call him, he will tell you in 2 seconds, Federico, those equestrian communities, those big dollar equestrian communities, you can look like a hero and you don't have to come up with the answer. You just refer him to Adam and you look like the genius. Again, there's no fee for his service, or it's like a filing fee. It's some nominal fee just to get the document in for the appeal. And then for a lot of people call me for CPAs. We recently hired this woman, Vanessa Bypat. Genius. I talk to CPAs all the time for clients or my own CPAs. They make everything so much harder. When I talk to Vanessa, I exhale. She just makes things so easy and so digestible, and nothing seems to be an issue for her. So you always want to have, the best practice is always giving 3 referrals, but here's 2 that you can pass out with confidence, and you can collect 2 more and you can dig them up. But you always want to give 3 to your clients just to avoid the concept of the claim of steering. All right, we're at 47 minutes and 23 seconds. Ryan, you want to close the show?
No, wow, Jim. Thank you for your expertise on this. Having a real estate attorney explain these and help us agents, avoid these pitfalls. I've had these exact issues as you brought up through this webinar. I'm now more of an educated agent, and I can handle those other buyers agents or the sellers, that are bringing up this issue. Can't say enough thanks on that, Jim. But yeah, I tell everybody this is a weekly webinar that we host. Tell your friends. We want to add value to the agent community. Also want you guys to check out RealTrade. Like I said, I launched it 2.5 years ago because I really didn't like what Zillow was doing to us agents. I wanted to empower agents, be able to build a personal brand and get direct leads off your listing. And I wanted to monetize it a different way, and we have, and we're growing, and it's very exciting. So check out, I put a link to RealTrade on there. We're an online marketplace and social media platform. So not only can you get free leads off your listings, you can connect with other agents, okay, on the platform. And of course, the awesome service providers like Jim and other lenders and other inspectors, appraisers, contractors. We got handymans, all those people that you need as a real estate agent in your quiver, you can actually get connected with on RealTrade. So best part is it's free for agents. So check that out. So
Ryan, you guys have 5x since I've known you.
Yeah, no, it's exciting, Jim.
5 times you've grown since I've known you.
Yeah. Yeah.
Very
No. There's a bunch of, some great tailwinds too for RealTrade with the whole NAR thing, which we've spoke about too as well. We've had a couple webinars on that, but I can't say enough good things about Jim. Guys, I use New Path Title for my closings. One of the big reasons why, of course, I like Jim, and he's 24/7 for support for you, that you can text him, which is amazing. But they have a great closing software called Title Leap. It's like a free contract coordinator for us agents. And the best part is it's free. You know, it's free, and they keep track of all your drop dead dates. You're getting text message and email. So if you know if your finance contingencies coming up or your inspection contingencies coming up, you're now notified, and it's great, and lets your buyers or your sellers know that as well. And I can't say enough things, Jim. Once you click over to Title Advance. Title Advance is a tool that I use now for every single deal that I'm working, whether I'm representing the buyer or I'm going to a listing appointment and I want to seem like an educated agent. It's free to use, guys. It's a free service that Jim's providing for us agents now, that you can know going into a deal if there's any kind of title issues. If there's some kind of crazy Y-green loan that's on title, if there's some kind of crazy thing from the IRS, or, you know, there's some kind of, you know, permit issues or liens, you can see now before you go into the transaction or before you even take the listing, hey, is there equity in this deal that I can actually sell this property and take this listing? You now know that, and it's free. And you can go to titleadvance.io. I actually shared the links in the chat.
And if you guys get something, if you get a transaction that has problems, you can actually order the commitment. You can order an actual title commitment. You can actually order a municipal lien search, and we'll pay you back at the closing the cost of your search. So if you order a municipal lien search, let's just say the property has open permits or something, and you order a municipal lien search, at the closing, I'll pay you back for the cost of that municipal lien search. So you've got all the tools we're using at your fingertips, and we follow up. Scott and I are doing the title advances. If we see problem transactions, we follow up and say, hey, you know, Federico, just a head up, or Guillermo, just a heads up. I think we sent you a follow up on one of your transactions where there was an issue. And you can get all those tools with no cost to you guys. And if your seller pays for it, we'll pay for this. We'll pay the seller back at closing. There's another link at the very bottom of the Title Advance website where you can order all that stuff too. All those products are available. Yeah, so there's a title search report for 175. That's the title commitment. We got to put all the rest of the products underneath there. And then we have the law firm. So if you guys have evictions or you have transactions, can you see the whole page, Ryan?
Yeah, make it a little wider. There you go. Now you look a little
Municipal lien search, I mean, municipal code violation issues, evictions, ejectments. A lot of attorneys don't know the difference between an eviction and an ejectment. We do foreclosures, we do contract litigation. The James Brown Law is there as a resource for you guys, make you look like the sophisticated agent. We're seeing a lot lately, probates. So you go to a listing appointment and the not sophisticated agent is meeting with Tammy, but Mary's in title, and they say, oh, Mary's my mom and she died with a will, and I'm the only person, I'm the only kid, so I'm the one who has the right to sell the property. Wrong. You still have to go through the probate if it's not held in a trust, and you still have to go through a summary administration if it's their primary residence. And it's not the end of the world, but it takes a little bit of time. So you want to set expectations, you want to understand what you're dealing with, and we can do that at the law firm, and we can take care of all those issues. That's all I got, Ryan. I don't know if you got anything else you want to go over before we part company.
No, thanks, guys. Too. Reach out to myself or Jim. Let us know any future topics that you want us to cover. We always want to, you know, like I said, add value to the agents here in the community and make sure that you guys are well informed and help you get and close more deals.
And crypto is coming back into vogue. For whatever reason, we're getting calls about doing crypto transactions. So if you know somebody that wants to do a crypto transaction, we're happy to put that together for them. There's a couple different ways that can happen. All right. Go out there, be the educated agent, walk confidently. Confidence is power. You guys know what you're doing. Now kill it.
Thanks, Jim. Thanks, everybody. Thanks for attending.